they will strike down the entire law and not just specific provisions.
So our objective is to strike down the entire law. Ganun na mangyayari.
Well, personally, ito naman yung difference ng mga petitions, no? I did not question cyber squatting, I did not question identity theft, I did not question even the pornography decision, no? But having not questioned them is a different issue from whether or not, without Section 12, you could have a viable law. And I think the Chief Justice asked the question, how do we save it, given that you drafted Section 12 the way it is? No? So, but anyway, since we subjected it to facial challenge, the reason why there is facial challenge is because it could cover protected rights, it is void, and therefore void, violating due process. The remedy really is for Congress to enact a new law. It's not for Congress to interpret it in a way that will survive constitutional scrutiny, because in one U.S. case that struck down the Louisiana criminal level statute, the court said that would be the exercise of judicial legislation. So really, if we succeed, they have to draft a new law. And let's hope that it's the House version that they will draft this time.
I think there's someone who joined the Giselle.
Of the National Press Club of the Philippines. I am also one of the lawyers who filed a petition challenging the constitutional merits of cybercrime law, representing the National Press Club. We joined the point of view of Attorney Roque. We do not care about cybercrime, cyber pornography, cyber sex, data interference, and hacking, because we believe that there are good laws, except the cyber libel law. In our point of view, it's very dangerous because, as discussed, articulately by Attorney Roque during the oral argument, it's overbroad. We do not know that there was no specific definition on how cyber libel or online libel is committed, who will be liable, how they will be liable, how it will be committed. Is mere liking or tagging or whatever, will they become liable also? Because we have to bear to note that cyberspace is a very intricate maze. It creates an intricate maze of interaction, unlike the ordinary publication, where basically there is no interaction. The publication is, or the expression of ideas or opinions goes one way. The readers, the listeners of a broadcast cannot comment, unlike in online publication where it creates immediate interaction among the participants. Like in Remate or other publications, newspaper publication, they already have the online version, where in the lower portion there's a reply section, there's also the chat portion or option in online publication. In other words, we also discussed that there can be no online libel on the ground that there is an immediate availability of right to reply. If one feels that a certain publication is inflammatory, they can easily go in the reply option and write their comments or counter-criticize also. In other words, in online publication, there is no monopoly of thought. There is no monopoly of ideas. So that's only one of the points that we raise to strike down cyber libel. And well, we did not specifically challenge the constitutionality of revised penal code libel, but in our discussion, we mentioned that all over the world, libel is already considered as civil in nature. They have already decriminalized libel. So in a way, while we did not specifically question it, we support also the challenge to towards the unconstitutionality or declaration of unconstitutionality of traditional libel.
Yes, Harry.
I
And
promise to be quiet after this.
no,
No, but no, but you know, I had a problem in dealing with how many countries of the world have actually decriminalized. Because I even consulted international organizations on this, the Media Legal Defense in London and Article 19, and they both came back to me saying, unfortunately, I wanted to be able to say on oral arguments precisely what Mike had said, the majority of the world have decriminalized libel. It's apparently not true. That's why I didn't say it in open court. Article 19 even has a map of the world on how many jurisdictions still have criminal libel, and because it should still a majority.
you mean a majority of countries still
A majority of
have
countries.
criminal
Now, my next question was, can I at least say that in Europe it's completely decriminalized? And the response is you can't, because France still has criminal libel. Although it's not actually, you know, a living law, because no one has actually resorted to it. And then my last question was, can I at least say that in the United States, all the states have decriminalized? And he said no. In fact, there's one case recently involving a blogger where he was convicted by a majority of a state law, no, under state law of libel. Although there's only 17 states in the United States that still have criminal libel law, which is a lot compared to 52 states. But it still isn't, you know, decriminalized in the United States itself. No? So that's why I couldn't say it was a Supreme Court, because it was not factually correct. But we can, however, distinguish, because it seems to me that in almost all jurisdictions that have applied and adopted the actual malice standard under the New York Times versus Sullivan case, they have decriminalized libel, because that's precisely the reason why it was declared to be unconstitutional on the basis of overbreadth. No? There's some protected speech which could be punished. These being false statements without knowledge that they were in fact said, that they were in fact false, or in other disregard of its falsity, against a public figure or a public officer. No? And the problem is, in some of the jurisdictions that have opted not to decriminalize, the reason is they have a different concept of malice, which includes a broader definition, including hatred, ill will, and malevolent intent, no? Which, according to the adherents of New York Times, should also be protected, because they contribute to the free debate of ideas and free market of ideas. But that's where the division is: how to treat hatred, ill will, and malevolent intent.
In the past, the late Congress introduced themselves, the lady beside the blog for June. Please pass the mic, Harry.
My name is Regina Lai Rosero from the Broad Media Foundation.
And I think to Ariel, please introduce yourself.
Morning, Ariel Sabulina from the Philippine Press Institute. The PBI, along with the NUJP, the National Union of Journalists of the Philippines, totally reject the bill or law in its entirety. That's why the Attorney Roque was tasked to be one of those who did the oral arguments at the Supreme Court.
Hi, I'm Ali Morendez. I'm a blogger and I'm from the PBI also.
You're going to say something, or is anyone has to introduce himself? Anyway, so there's a range, this question now. No? What somebody asked earlier, what will remain of the law if the convention provision on libel is taken out? And Harry, you were saying it will not save the law. I mean, the law cannot be saved. And you're saying that the law can still be saved even if the provision on libel is taken out.
Not actually, because all of the petitioners are with common opinion that once Section 12 is strike down the entire
Somehow we
law.
can show section 12 there. Anyway,
I have.
anyway later we can show it. So, please
Once
continue.
section 12 is strike down, it will be impossible to implement any provisions.
So how do we proceed from here? Anyone maybe comments, questions? My understanding is that if the Supreme Court comes out with a decision that still keeps the law but only takes out a certain provision, Congress can still enact a law to decriminalize libel.
Pretty much that's the ongoing debate now.
Do you have a mic?
I can imagine that the ongoing debate in private amongst the justices is, can we save the all the question provisions are classified under content-related offenses, which is the second kind of offenses that's being punished. So I think they're questioning, okay, let's completely do away with content-based offenses, especially libels, cybersex, probably pornography, because no one challenges it will remain there, and the definition anyway is very narrow. But the question that they're asking is, because the challenges are an overbreadth, can we at least limit the declaration of unconstitutionality to these content-based offenses, no? Or really do we have to set another law? That's, I think, the question being discussed. No? And the reason precisely is they shouldn't have put 12 there as a means of monitoring and implementing the law. But as I said, any which way, Congress has to do something anyway. So if Congress has to do something anyway, they might as well start with a clean slate.
So do we need to await the Supreme Court decision? Does Congress need to await the Supreme Court decision before enacting a law to decriminalize libel?
Well, I think that was the intent of the Supreme Court when they issued initially a 120-day TRO. Because normally a TRO has no life when it's issued by the Supreme Court until it's dead. So it was as if they wanted Congress to do something within a fixed period of time. And they didn't do anything at all during the 120-day period. So they extended it until further notice, which really is the validity of Supreme Court issued TROs. But I think that's not a too subtle message to do something about it. Alam mo, one disappointing thing is this Asset Hieronymus C, who is head of the Book of Crimes project of the DOJ, already had hearings on libel, and Ariel was there, so it's not just me. And that is why in the first oral hearing, I asked for a stipulation from the Sovereign that in the Book of Crimes project, which is an executive initiative to be recommended for enactment by the legislature, they already came up with a proposal to decriminalize. And I even identified that the chairman of the Book of Crimes that covered the libel provision is Assistant Solicitor General Makaraig, ano ba ang name ni Judge? Palagi kong naaalala Makaraig, which is the sister of Twin, Guillen. So, in the next hearing, I noticed that ASG Guillen was there, so I asked her, will you stipulate? And then no. Because Asset C does not want us to stipulate. Sabi niya, we are going to still adopt a libel provision law subject only to penalty of fine. So I told ASG, but that's not what we agreed upon in the public hearing, correct? She publicly pronounced that the recommendation was to no longer provide a criminal penalty for libel. And then she smiled and said, well, that's the position of Assistant Secretary Ron Musi, who's chairman of the project. So I'm inclined actually to write the private funders of the project and to tell them to stop spending money. Because in the course of public consultations, they ignore anyway what they get from the stakeholders. And they ignore even the recommendations. If C wants to write the whole Book of Crime himself, let him do so without spending money from donors. Yeah? And I guess I will also go on record here that the whole problem started with Hieronymus C.
Yeah.
Because in the first place, he was the one who introduced all the objectionable provisions, and this has not been given much attention by the media other than by Raisa Robles. He went on record that there's something on the internet where he exclaims proudly that he was the author of all these objectionable provisions. Now, in my mind, there's a breach of law here, especially on Section 20 and Section 12, the takedown provision, because it's no secret that he has been aspiring to have the office to be created by the law. And it was through him that the takedown provision and the monitoring provision was inserted. In effect, he wanted to give himself extraordinary powers since he was so sure that he would be appointed to this office. That to me is graft. That's why I'm hoping he would sue me. He doesn't sue me. I say it over and over again. I'm telling him, sue me, sue me. Wala. But it's on the internet. I couldn't believe my ears.
Any more?
This case is related to cybercrime, but you were the one who filed the case of Adonis, the journalist, who were libeled in the United Nations. What is the leverage of the United Nations human rights? I think commission, no? Which ruled out, so that's why Adonis now is free. No? What's the update on that?
Well, okay. In fact, this is why Adonis became our lead petitioner. Because we wanted to enforce the decision of the Human Rights Committee view that criminal libel is contrary to Article 19 of freedom of expression. Now, that's one of the issues the court will now have to resolve. The problem with the Human Rights Committee is that pursuant to the optional protocol itself, it is not binding. However, when you ratify the optional protocol, you recognize the jurisdiction of the Human Rights Committee, composed of experts, to receive communications from citizens or state parties complaining about their own states not being in compliance with the ICCPR. And in the Supreme Court, I noted at least one case where the International Court of Justice said that even if it's not binding because it is the view of experts created for the purpose of monitoring state compliance with a particular treaty, it should be entitled to great weight. And then I also pointed out that there's at least 2 cases in the Philippines where the Supreme Court applied, in fact, human rights views. And the 2 cases are on the issue of discrimination, IS educators versus TCP, as well as the case of the Manolo brothers versus Teodoro, where the court in fact cited no less than 25 human rights views issued against different countries. And I asked the question, if in these cases, the Philippine Supreme Court applied the views when they were against foreign countries, why should it now not apply a view against the Philippines? Although Justice Marvin was very strong in his position that doesn't bind us at all, which of course the Solicitor General harped on when it was his turn to argue. But this is not the first time I have invited the court to rule on the weight of human rights views. I have another one that has gathered us in the Supreme Court, a human rights committee view saying that prison conditions in the Philippines are torturous. And this is a publication filed by an English national who was detained in the Philippine jails. No response still also from the Supreme Court. There's 2 studies, one made by the International Law Association and another made by the Open Society Institute. Unfortunately, their conclusions were state countries were very poor in implementing human rights committee views.
Isn't there a move to make, I don't know, I'm not aware of, make international protocols binding?
Well, correct.
Yeah.
In fact,
Maybe it's something, can we do it by legislation here? If we can, are there countries which have done that, where they've made international protocols binding?
what I did in order to popularize the issue, unfortunately, it wasn't really given much attention by the media either. I invited the president of the Human Rights Committee. He came and left very few reports about his coming and going. And he said that they're trying to strengthen the follow-up mechanism, or follow-up mechanisms to ensure compliance with their views. But he did say that if you go through the records of the Philippine review, no, by the committee which was held last year, late last year, Secretary De Lima was stunned at the level of questions thrown at her by the members of the committee, no? Because many of them involved, including the Adonis view. Why did you not comply with the Adonis view and even come up with the cybercrimes law? No? But all this is a matter really of you are declared to be in breach of an obligation. You can or you can keep the view, but it seems to me that we should be cognizant of the fact that we should be at the forefront of heeding the findings of these expert bodies, if only because we are also involved now in many proceedings which may entail nothing more than a declaration of whether that you're in breach of the obligation. And I'm talking specifically about China. If we ourselves don't pay attention to declarations that we are in breach of our treaty law, and if we succeed in our arbitration that China is in breach of international law because the 9 dash lines has no legal basis, if we ourselves don't implement the views and don't correct our breaches, how can we say a state like China should in fact honor its treaty obligations as well? So I think that's a strong argument on why we should honor all these declarations.
Any more questions or comments or based on what we discussed so far, of course we're all awaiting the Supreme Court decision, but there are maybe just to make it clear in our minds that the Supreme Court, I don't see it, Harry, correct me if I'm wrong, I don't see the Supreme Court striking down the entire law. I mean, I don't think they'll do that. But in the meantime that we're awaiting the Supreme Court decision, can advocates push Congress to already prepare? At least, when will the new Congress convene? July 1, no? But we still don't know, of course, who will win. But I think the advocacy for the criminalized libel should continue, as Dr. Braid suggested. Maybe it could be part of our those who of questions posed to senatorial candidates and candidates in Congress. What is their stand on the criminalization of libel? Because as we saw earlier, the disagreements among the petitioners are real, and I don't think there will be a united position taken. So yes, please take my joke.
Can the stakeholders already prepare a draft amendment to the law so that when Congress opens in July, we can immediately give it to them and act on it, and for the legislators to act on it, at least if we're expecting the Supreme Court not to jump the whole thing?
Yes, there's a suggestion here. Anyway, we're taking up all the suggestions.
Yeah, actually, we exerted some effort already beforehand na we tried to contact the office of the senators. But there's one senator, which is Senate President, sinabi niya na pending pa raw sa Supreme Court yung batas, yung pinag-uusapan ng cybercrime law, anti-cybercrime law. Kaya hindi raw nila pwedeng pakialaman. Mali yun, di ba? They can come up with law na yung para bang to save their faces, di ba? Na aminin na nila mali yung law na nilabas nila. So, basically siguro kung if you have one voice na lahat tayo come up with yung proposal kung ano yung gusto natin sa cybercrime law na magbigay tayo mga suggestions dun sa kanila, then magkaroon tayo ng open letter para sa mga senators, sa mga congressmen. Siguro naman especially itong sa yung tungkol sa libel, yung decriminalizing libel, and at the same time, ito naman sa anti-cybercrime law, di ba? At least may mangyari, di ba? Sa dami naman natin, I don't think hindi tayo nakikinggan. Kasi just like what Heron Musi told me, pwede naman daw muna natin tanggapin ito This is just like the operating system of Apple, which is 1.0, and time comes magiging 1.1 daw yung 1.2. Sabi ko, we're paying for the operating system of the government, no? We're paying for our taxes, na yan ang sweldo mo. So we need it to be accurate na at least 99.9% na maayos yung laws na ipinapas nyo, rather than we'll pay for another operating system which is 1.1 na bungal-bungal yung batas na ginagawa nyo. Yun sinabi ko sa kanya. But wala, arrogante ka usap. Hindi, I can tell him na arrogante ka usap itong ASIC na to. Seems like, alam mo parang siya yung Diyos na yung, hindi, tama itong batas na to. Nakaharap ko siya in an interview sa ABS-CBN, talaga. Sabi ko, ASIC, alam mo, yung sinasabi mo, hindi namin malunok. No? But siguro, lapit na tayo sa mga lawmakers. Kuha tayo, sama-sama na lang tayo sa manifesto tayo. Diba? Kung ano yung suggestion ng ibang grupo, pag-isahin natin. Sa tingin nyo, Attorney Roque, okay ba yung naman?
I think we should go beyond that. No? Alam mo, nung pumutok itong controversy din, hugas ka na yung marami yung cheese na hindi ro nila napansin. And now that we know how much they're actually giving as senators, ano ba naman yung basahin yung final draft of the law before they vote on it? Mahirap ba yun? I think that's the kind of criticism we should hurl at them. No? It's no defense na, sorry, hindi namin napansin, considering that they get not just 200, ano ba nga yung calculation ni Miriam, how much per year? Sobra-sobra, almost 50 million per year. Eh, siguro naman, bago nila taas yung kamay nila na no objection, ibabasahin nila yung batas. But as far as advocacy is concerned, I think the fact that the young people finally prove that they are not complacent, that they will be heard even in internet, has shown that there is hope in extracting promises from these individuals. I was very much impressed by the activism shown by the young and the ones young, no, on the internet. No? But it was spontaneous. No? And no one could claim credit for it, even if some are in fact claiming credit for it. I think people were just like, this is a communication that we like because it gives life to liberty and we can't mess around with it. If we could tap them to make these elected officials accountable and to promise that if nothing happens that they will in fact heed the demands of the netizens, it would be great.
You said, Harry, that we should go beyond advocating a different bill to decriminalize libel. Do you mean to say there should be a group that will campaign against those who voted for the cybercrime law?
I think they should be held liable, no?
Yeah, but that means that those who are running among them, I mean,
we should
the netizens should point that out.
Correct, no? Kasi pwede ba naman yun na, I'm sorry, hindi ko napansin sa final version. Di ba? I mean, come on. Di ba?
Yes.
Ano naman matitira sa kanila? Kasi
Aking din nagbabasa.
We'll call on them to...
Under question, really, what do we do? I think yung point ni Harry, that's one step. We should remind our lawmakers to be more diligent in passing laws. Beyond that, I think we should be proactive and progressive. I saw this in 1986 when I was with KDP. I chaired the advocacy committee. None of the broadcasters then, that's how we met Flor, had a legitimate license to operate because Marcos removed all these licenses and he has presidential decrees favoring certain players. At that time, it was the BMC, Broadcast Media Council, that provided permit. When Cory came and there was no constitution at the time, we all met. And we said, paano to? Wala tayong lisensya. You know, the chaos that created that was there at that time gave us the best opportunity. It was the moment of history that the broadcasters became a self-regulatory body. And this is where I think we should focus on. On one hand, we like libel, okay? But as a civil in its civil form. we have to remove the criminal liabilities. On the other hand, the society is growing, internet is exploding, certain ethics, certain ways, right ways, high standards of practices of media professionals have to be encouraged. So our group, so at the time in KBP, we said, let's put up the Program Standards Committee. Who will determine that something is obscene or has gone beyond the levels of decency? And we always said, no, government is not the one that should say. We are a self-regulatory body. So this is a challenge to us. I think our organizations have to prove that much as we hate the criminal provisions of the law, the proposed law, or the law that was passed, we should move forward and standardize our profession as media professionals. Maybe like compete, kapisanan ng media professionals sa internet, but I don't like the word compete, reminded me of a political party. But we can think of another name. And when it comes to content, no government should dictate upon its people what would be the standards of decency. It should be the people themselves, the professionals themselves. You and I, our organization, should have a code of ethics, program standards. KBP has that. That's number one point. The number 2 point, when cable TV arrived, I was in the broadcast side before I put up the cable TV business. We said, let's inject the must carry provision in the cable law, which means free TV, which have been entrusted by the state to use frequencies that belong to the patrimony of the nation, should always be available whether there's cable or not, and that operators must carry free TV. So it got included, so it protected the interests of the free TV players. It also helped the cable TV operators to grow their business. You know, this is 25 years ago, 86, now it's 2013. We've seen this before. If the players, the professionals in that industry fail to see the opportunity to set the standards, government you will always set by Hieronymus. So I see Hieronymus not just a person. It's a fact of life. We had before regulators who wanted to define what excellent in programming is in TV. So I think that's one challenge. Let's be proactive and professional, organize ourselves, and show that media professionals and the internet can set the standards. And if there is a case against any of our members, then they will use our program standards or code of ethics as a basis for their lawsuit. That some of our members violated our own code of ethics. So that could be one. KBP is very strong in that aspect. So MTRCB comes in merely to classify content, whether it is XXX or good for children. Hanggang dun lang sila, but they cannot touch foul language, or they can warn, but they cannot dictate what is acceptable within the limits of the business. That's one.
Proactivity, and also maybe going beyond, should be maybe relating to cybercrime, go to other bills, laws on freedom of expression. The non-passage of the freedom of information is an indicator of some lukewarm attitude towards access to information. Maybe when we carry into the 16th Congress campaign, maybe we should really reach out to more people so that they can understand how important critical information is. We tend to think of that, well, as long as our basic economic needs are satisfied, okay. But what we forget is that information is very basic. We don't have access to information. No amount of economic information will help. It is understanding, it's having literacy in all forms, political literacy, economic literacy, which really means information, knowledge, management, and information access. So if we broaden this our campaign for freedom of expression, then let's try to also examine all the other bills that are lying still, now dormant or are in ICU because of lack of interest in access to information, the right to know, the right to information. And there are still laws. Even laws on antitrust are information rights law, where you try to broaden access to or ownership of information, see business sources, should be our concern. And we hope that we all belong to the information community that we can look and plan ahead. And maybe this is the time. When they go around, they've started moving around the country today, senators and other government candidates. Often information is neglected. They talk about economics and other issues, but this is an issue that's often, maybe sometimes you may well talk about it, but then when it comes to implementation. So perhaps we all belong to different journalism communication groups. So I think maybe even before we adjourn today, we should come up with some concepts or statements that we'd like to be integrated in future legislation that will be crafted. Is that right? That's what we like. And strengthen this advocacy. Maybe our groups can, maybe next time we have broader, larger, invite other groups to join us. But I think maybe some of these procedures should be edited and we don't do justice much. It is one form of advocacy for us. We're happy that we have this channel, and that was not made a big share, but mobile media said that internet eventually will be passé, and we're moving to the mobile media revolution. So, what does this mean? These are the technology is moving so fast. We're talking now about internet law. We're moving now towards mobile media.
Before we end one, Joe.
I just would like to suggest, because as Professor Roque said, there's a lot of actually different interpretations of what we're fighting against or what this anti-cybercrime law is about. Can we just have maybe a unified interpretation of what we are, for example, our organization, we go to our members and we do campaigns, for instance. So we will have a clear understanding what we're opposing and what is Section 12 and all these things that Professor Roque said. Maybe we can draft some guidelines or campaign thing that all of us, all organizations will have in common, because maybe when we go to Cebu, for instance, we will be talking about this, and then another organization is talking about this, and we will be, we will just be confusing people. So maybe we can have something, one thing, and then everybody will be talking about that, so that people will not be confused. And especially on cyberspace, there's a lot of confusion also what we're talking about. And then second, about the suggestion of Dr. Bray, maybe we can have another, in the future, another forum to discuss proposals, or even, I don't know if we can experiment on a citizen-generated bill for the next Congress. Maybe we can have our own bill that we will file in Congress, and we will have citizens sponsoring that bill, because as observed earlier, there's a lot of us, there's thousands, millions of netizens and people interested on cyberspace. Maybe we can have something, initiate something, maybe not even an amendment, but a bill itself that will, that is also consistent to policing ourselves or regulating ourselves. And I think that would be a future endeavor.
Okay. June and then Harry.
Siguro I'd like to suggest, as we've been working on one proposal that was drafted, it's the Magna Carta for Internet Freedom. It's still open in the sense that, to give you an insight on how it was organized online. It's basically, there's a purpose to it, is to extend the rights we have offline, online. It's as simple as that. And the purpose of that, and we were able to generate a community, and we're still generating a community who are discussing, working, and working on the project. I mean, it's open to everyone. It's also highly transparent. So anything, any document, and anything that's discussed can be seen, can be accessed online. So far from my experiences, the only way you can work on the internet is to be transparent. Otherwise, your motives will be questioned, even the project itself will be questioned. So it's there, it's democracy.ph, democracynet.ph. The bill is called Magna Carta for Internet Freedom. It is, in a sense, because the internet is a lot of people, and some people are contributing, some are working on the sidelines, for example, talking to congressmen, talking to senators, and they're political animals, so they're timing everything, they're timing this and that. That's a given. And we've been reaching out to different communities, software developers, and you get different responses, like the developers would like to join in, but they don't like to join rallies. Then you have people against cyberbullying would like to come in, but they would like to have a section on cyberbullying, which is fine. The transparent discussion. So I think it could that could be expanded. There's no true authors in a sense. The authorship is the community. That's it. In Isabati, which often is neglected, even the internet, is, and which can be taken as an advocacy here, is the digital divide. Most marketers will tell you the internet penetration rate in the Philippines is around 29% to maybe at the most positive 40%. And you have your targeted growth in terms of mobile or broadband mobile is 5% or 5% per year, something like that. This is based on a study commissioned by UNICEF with the Broadband Commission. Now, why am I telling this? Most of the local officials, most of the senators are national. The congressmen are local. So it makes sense in a way that they don't actually look at this as important because it's not with the internet penetration rate of 30 or 40%, it's not really a local matter to them. But it is a good advocacy for communications, for journalism to, I would say, increase the penetration rate. And we do have technologies that can advance this. For example, mobile phones by broadband can expand this. And it is an issue. It is an issue that's not much talked about on the net because it doesn't affect people on the net, to be honest. It affects people not on the net, offline. And even people offline who don't have computers at home, go to the internet cafe, but it will cost them X amount of money an hour just to access the internet. So there is a divide there. It's a digital divide that is economy in sense that affects your access and your speed. Right now, I have the Sky cable, which is $999 per month. but it has a data cap. So if I exceed 10 gigs, it automatically shuts off. So right there, you have a divide between somebody who has a 30 gig access but has to pay 30,000, and somebody has 99. Why am I saying this? It's a good issue in the sense that a lot of our countrymen are not really that connected. It could be an advocacy in part of the cybercrime, it could be part of legislation as well. Because it's important, because whether the cyberspace is via mobile or via computer, it is a democratic forum. And as such, mas maganda ma-promote siya, I would think. And it has shown na in terms of crowdsourcing, it's a very good means of crowdsourcing once you're connected. As long as you have a purpose and you're transparent. FIFA worked that way. Because if FIFA had a Facebook account, it had 1,000+ members. And if you went to the Facebook account and you would watch the thread of discussion, it can be very funny, very vicious, and sometimes very personal. But the key was you had coordinators who were keeping people on track. So this is an insight on how the crowdsourcing thing works. The Democracy.ph works the same way as well. At least we have, I think, 300 members so far. And the trick is not to say that, like the other secretary would say, or the ASIC would say that this is the version. The trick there is actually it is the version for everyone. So if there is a suggestion, suggest to it, let's discuss it, let's take a vote on it. And if people respond to that.
Irene, I think we have time for us.
Well, it's all about truth. No? I think the message in any advocacy is it's all about truth. Why do we object against libel? Because the current law in libel does not recognize truth as a defense. When precisely the reason why we have freedom of expression is it is the only means by which we can find out what the truth is. What I'm saying is it's because it's all about truth, we should relate it also to other issues that Congress has not addressed, including FOI. I've always wondered why the FOI proponents are not the same people advocating for the previous title, when it's all about the truth. And that is one ground, in fact, that we argue why the libel law should be decriminalized, because precisely with the recognition that there is a right in the Constitution, there is a right to information for people, then the provisions on truth becoming not a perfect defense, not only defense, is no longer feasible under the Constitution. But even amongst organized media groups and civil society groups, the problem is we're not able to package our advocacy under one single theme, and which in my mind is very clear. All this struggle for FOI because we want the truth, we want a mechanism for accountability.
That's a good way to, I think, end. Angelo? Yeah, please.
His experience in grassroots, internet, I mean the use of cyberspace for the grassroots would help us also.
Yeah, so our organization, which is the Philippine Communities and Center Network, where when it comes to this issue, it's right that one of our speakers was mentioning that about the process that actually in many of our municipalities, in the provinces, there's a process of inclusion. So we're still in the process of bridging that digital gap. But I think that that's one advocacy that we're really promoting right now, is providing access to information to as many of us, as many of our Filipino countrymen as possible. And I guess what's a very important component that we need to advocate there is, access to information should also be access to what is true, what is the right thing for people to get. And right now, I guess personally, being neither a lawyer or a media person, I'm really more concerned on what would be, well, if at all, what form the final law will take if it's going to be passed. So we're concerned about all these people we're bringing in, all these new netizens that we are developing from the countryside. We're training all these people to to use computers, to use the internet, to be involved in the discussions in cyberspace. But we'd like to maybe, one reason I'm here is maybe we'd like to get some help or assistance in perhaps coming up with guidelines, because we do a lot of education, a lot of training, a lot of content development, and where does the issues of freedom of information, the risk of getting punished for libel or whatever crimes. We need to maybe be enlightened more about this, get more guidance, so that, for example, we can develop guidelines for people who are using our facilities, these community centers in these communities. So at least on our side, we think that we need to be responsible in educating our people on the proper use of the internet, and people to be more educated on issues like privacy, issues like intellectual property, and perhaps issues like libel if it's comes to pass. So basically, that's what I'd like to get guidance on in terms of also developing our advocacies for providing internet access to people in the provinces. Thank you.
Before Mr. Velarde closes our anyway, we have another member of this discussion, Attorney Terry Ridon, National President of Kabataan Party List. You're one of the petitioners as well?
I'm one of the councils.
Okay. Anyway, this can continue over lunch, but let me just, before Mr. Velarde closes this, I'll just read a few points that were suggested that can be taken up in the future. AIJC and Justice Channel, Watch Channel, may convene another forum. But the ideas that came out include lobbying for a law to decriminalize libel, including drafting the law itself, maybe crowdsourced as suggested or prepared by advocacy groups. Of course, the most immediate is to campaign against those who voted for the cybercrime law. Of course, journalists, we cannot do this, netizens, really, non-journalists. We have to be non-partisan. But they should be held accountable for their votes. Maybe this could be part of the information campaign. Another suggestion is to link, it's actually a good suggestion by Harry, to package the entire advocacy under one theme, like it's all about truth, to link FOI campaign, the decriminalization of libel under one campaign. The other suggestion, of course, is to pose questions to the candidates running for Congress and the Senate, what their stand is on libel as a criminal offense and parts of the cybercrime law, as well as FOI. And Joe says there's a need for a unified stance on when we talk to our constituents, our members, what do we tell them when we're opposing the cybercrime law? Now, what is the common ground? Actually, I think it's difficult, but maybe we can find that. And to a suggestion that let's all look up the democracy.ph for the Magna Carta for Internet Freedom, and also include increasing penetration rate as an advocacy issue, both for legislation and media campaign. And Angelo discussed the need for guidelines for training the users of their facilities in LGUs, in various communities in the country. And we also need to bridge this divide. We have a lot of information, but making legal is reaching the community. So on that note, I'll ask Mr. Velarde to close this forum.
Thank you, Dr. Flora and Marites. Just for 3 minutes, allow me to close. Most important, we have lunch prepared for everyone, and we should continue the discussion. This conversation will continue as well using some social website that we're developing. Please feel free to participate as a blogger there. I just have 2 points. One, I want to thank the petitioners, Harry, your group. For the first time in the history of our country, this issue of libel as a criminal offense has been brought to all of us. No Congress will initiate a law to decriminalize that for many years. Why? It's the defense of criminal syndicates, where you have syndicates in government, syndicates in the judiciary, syndicates in the police, and the real syndicates. They use that as a tool against you and me as journalists. They will get a judge at 5 o'clock in the afternoon on a Friday to issue a warrant of arrest, to arrest journalists like you and me. And we will stay there for 1 whole weekend to Monday before we will be released. You know, if you're a criminal in a city and there is one journalist who is a disciple of truth, and you're the only one fighting him, he can crush you immediately. In fact, why journalists are being killed? Why? Not that he's the most, or he's the noisiest or the loudest. Because he's the only one fighting. And all of us are not fighting because of the fear that the truth might send us to jail. So you have very few Marites people now. But before, you had Ninoy Aquino, you have the colleagues of my father in the martial law time. They were all fighters, but many of them got old and their future was spoiled from that. And I think this is the only time, because who will be the congressman who will do that if you're involved in crimes in your own city? Nobody. That is their mistake. They included a criminal provision in a cyber bill of which they do not really understand, and just inserted it thinking that they could do their thing and do it all the way and succeed. But this generation have people like Harry and you fighting the criminal provisions of libel. And this is perhaps the only time we can convince the Supreme Court to amend that law, that old law. In fact, what should the question be is not how many of these countries have decriminalized libel. No, the question is, how many of these countries whose governments are democratic, who have strong civil liberty provisions in their constitution, have in fact decriminalized libel? And that is the model of our progress. Well, with that note, I hope you will take the lead in professionalizing our profession. You know, in 1968, the photographers of Luneta, my father would bring me there, take a picture, we sell at 2 pesos. And later on, anybody with a camera become a professional photographer. So in 1970, I sound like an old man, but 1980, we organized Professional Photographers Association of the Philippines, PIPA, with Sarmiento and Eddie Wang. In 86, anybody with a microphone becomes a broadcaster. So we organized the KBP to professionalize broadcasting. Now, you have a pen, you have a phone, you're now a blogger. Anybody could be a blogger. But we have to professionalize our trade. And I think you should take the lead in organizing, create code of ethics, make our parents comfortable and secure that their children, our children, are protected from the evils of the internet. At the same time, protect our rights. At the same time, we would police ourselves from the abuses this new animal called internet could perhaps create surreptitiously and irreparably. With a point of floor, old internet is really dying. The new internet is just a mobile and it's on the phone. Take the lead, and we who are in the private sector, who are in the telecoms, media, tech, and academic business, will support you. Organize and we'll support you. Have a voice and tell society and the lawmakers that there is now a strong organization, not disparate, not anonymous, not disorganized, but they have a face
and people could go to them for issues like cyberbullying, issues like pornography. And why give it to the government, that particular function of society? We should take it, you should take it, and we will be your supporters. Thank you very much for attending today, and let's continue the discussion over lunch and in the next few days. Thank you.
Thank you, and let's give each other our